I never thought I'd need a lawyer just to keep what I already owned. But that's exactly how it started. Because one quiet morning, I woke up to a bright orange notice staked into my yard, right where my grass meets the old oak tree. The paper said I was encroaching on adjacent property. Encroaching on land my family had owned for almost 20 years. First, I laughed it off. I figured it was a mistake. Wrong address, wrong lot, wrong everything. But then I looked across the fence and saw my neighbor standing there, arms crossed, watching me read it, smiling. This wasn't an accident. Let me back up. I live in a semi-rural subdivision outside the city. No HOA, wide lots, long driveways. The kind of place where people mind their business or at least pretend to. My neighbor, Mark, moved in 2 years ago. He was polite at first. Too polite. Always asking questions. How far does your property go? Did the previous owner ever show you the survey? You ever thought about selling a strip of this land? At the time, I thought he was just curious. Maybe planning a shed. Maybe dreaming big. Turns out he was planning something else entirely. See, between our properties is a strip of land about 12 feet wide. Trees, brush, nothing fancy. But to Mark, that strip was gold. He wanted it. And instead of asking outright, he went the legal route. Or at least he tried. That notice claimed my fence, my trees, even part of my driveway were sitting on his land, based on a recent boundary assessment. Funny thing was, I never saw a surveyor. No flags, no markings, nothing. So I did what any normal person would do. I walked over and asked him what the hell was going on. He didn't yell, didn't argue. He just calmly said, according to the county, that land was never legally yours. That's when I felt it, that cold drop in my stomach. Because confidence like that doesn't come from guessing. That night, I pulled out my closing documents. Deed, plat, map. Everything looked clean. Clear boundaries. No easements. No shared lines. But Mark had already filed paperwork. He claimed a technical defect in a decades-old subdivision filing meant the boundary line was ambiguous. And while it was under review, he requested temporary control of the disputed land. Temporary control, which meant he could use it. Within a week, he had contractors out there, measuring, clearing brush, talking about extending his driveway. On my land, I called the county. They said it was under investigation. I called a lawyer. He said, don't touch anything. That was the hardest part. Watching someone slowly take what's yours. And being told to stay quiet. Then Mark crossed the line. Literally. One morning, I came home to find my fence removed. Not damaged. Removed. Neatly stacked like it had never belonged there. That's when I knew this wasn't just about land. It was about control. And Mark thought he had the upper hand. What he didn't know was that I had one document he'd never seen. And it was about to flip everything upside down. The funny thing about paperwork is this. Most people don't read past the summary. Mark didn't, because if he had, he would have known his entire case was built on sand. See, when I bought the property years ago, my father insisted on one thing. He said, always get the full title history, not just the deed. At the time, I thought he was being paranoid. Turns out he was being smart. Buried in my records was a supplemental land agreement filed before the subdivision was finalized. It referenced a corrected boundary, approved after an initial survey error. And that strip of land? It was specifically mentioned. Not only that, but the document included GPS coordinates, notarized signatures, and county approval stamps. In legal terms, it was bulletproof. So instead of confronting Mark, I did something better. I waited. I hired my own surveyor. Quietly, professionally. He confirmed it in 2 hours. Then my lawyer filed one motion. An emergency injunction. Mark got served on a Tuesday. By Thursday, his contractors were gone. By Friday, the county called me back. Suddenly very interested in clarifying the matter. The hearing was set for Monday. Mark walked in confident. Smug. He brought charts, highlighted maps, and a lawyer who looked like he billed by the breath. Then my lawyer slid the document across the table. The room went silent. The county clerk leaned forward. The judge adjusted his glasses. Mark's lawyer asked for a recess. That's when I knew it was over. Turns out Mark had relied on an outdated filing, one that had been superseded but never digitized properly. He assumed no one would have the corrected version. He assumed wrong. The ruling was fast. The land was mine. Always had been. Mark was ordered to restore the fence, remove any alterations, and cover legal costs. But the best part? The judge added a warning. Any further attempts to claim the land would be considered fraud. Mark didn't look at me on the way out. 2 weeks later, a for sale sign went up in his yard. The fence is back now. Stronger, deeper posts. Sometimes I stand by that oak tree and think about how close I came to losing it. Not because I was wrong, but because someone thought I wouldn't fight back. So yeah, if someone ever tries to take what's yours using a technicality, make sure you know what paperwork they haven't seen yet. Because one document can change everything. And that's the part nobody tells you about property battles. It's not always about money. It's about who knows their rights. Because sometimes the loudest person in the room isn't the one who's right. They're just betting you won't push back. So if this story proved anything, it's this. Paperwork beats pressure every single time. If you enjoyed this story, hit subscribe for more real-life property disputes, neighbor drama, and moments where entitlement runs headfirst into reality. And tell me in the comments, would you have fought this or walked away? Because the next story is even crazier.